a principal lawyer and founder of Remote Law Canada, a law firm specializing in civil litigations, employment law, and remote work. In both 2018 and 2019, she's been nominated for Canadian Lawyers Top 25 Most Influencer Lawyers, and in 2019, she was featured in Forbes. And Tara is also LinkedIn Top Voice as well, and she's representing award-winning firm of her own. Tara, welcome to my show. Did I miss anything? Did you want to add anything?
No, that was a fantastic introduction. Thank you so much. I'm so excited to dive deep into these issues.
Leaders do to manage it properly when it comes to someone calls in sick. Let's go from number one. What is the policy when it comes to sick days? People, do they get fired for calling in sick too much?
So, the policy, it depends on the province, and it also depends if you're working for a federally regulated employer. So I'll give two examples. I'll talk about Canada, and then I'll talk about Ontario. So employees that are under federal jurisdiction, so if you're working for typically the government or any entity that's under federal jurisdiction, whether that's airspace and many others, those employees are subject to the Canada Labour Code. So, previously they were only allotted 3 paid sick days, keyword being paid, because in Ontario they're unpaid. But as of December 31st, 2022, that's just passed, employees that have been continuously employed for at least 30 days will have access to the first 3 days of paid sick leave. But as of February 1st, 2023, they received a 4th day, and then they continued to accumulate 1 day a month after February 1st, 2023. So at this point, it would be 2 extra days, up to a maximum of 10 days per year. So the idea is by the end of 2023, federal employees will have 10 paid sick days per year. The employers typically can't do much when a sick day is requested, but they can request a medical certificate if the employee is absent for 5 days or more in a row. Because at that point, it could eventually become some sort of extended leave. So 10 paid sick days for employees under federal jurisdiction. Now, when you turn to Ontario, things are pretty different. So employees in Ontario are not subject to the Canada Labour Code, but they're subject to the Employment Standards Act. And under the Employment Standards Act, they had 3 days of unpaid job protective leave for each calendar year for personal illness, injury, medical emergency, and it doesn't have to be related to work. Those 3 unpaid days, apply immediately, so they're not prorated. So if you're hired halfway through the year, you've still got 3 unpaid days. Now, they only have to work for the company for 2 consecutive weeks to be eligible for those 3 unpaid sick days. Now, a lot of people confuse this with the 3 paid sick days that came on the scene during COVID-19. So as of April 19th, 2021, employees who missed work because of COVID-19 got 3 paid sick days. That was supposed to end on September 25th, 2021, and then it was extended, and now it's been extended to March of this year. So slowly fizzling out. But that's the stark difference just between Ontario and Canada. So you can imagine that it really varies depending on which province you're in, unless you're a federally regulated employee, which in that case, it will be 10 years by the end of this, or 10 days by the end of this year. Can they get fired for taking too many days? I mean, that's an interesting question. So, really, employers can't force you to use sick days for your personal time, but they also have the right to ask for medical documentation when you go on an unpaid leave of absence, so that's more than that 3 days, or when you take any sort of medical leave, specifically like short-term and long-term disability. So if you do not provide sufficient medical documentation, and medical documentation doesn't have to include a diagnosis, but it does have to include, and this is what employees often forget, a return to work date. So if you're deciding that you're going to take a stress leave or a medical leave, and even though it's unpaid, let's say your doctor says that you can't work for 4 months, that's fine. I mean, as long as they've got an end date, the employer has an idea and they can't let you go while you're on that medical leave. Now, if you don't provide an end date, they could claim that the contract has been frustrated, the contract being the employment agreement, and they could let you go because it could be seen as abandonment of your employment. So, the first asterisk on that is, well, they can't let you go if you've got a sufficient end date, but they could let you go if you don't. And then the second part to that is that you have to remember that employers can terminate an employee at any time without cause. Even if you were on a sick leave, the fear is just that the employer would be on the hook for wrongful dismissal as well as maybe some human rights damages. But they could terminate you at any time. They just have to pay you out appropriately.
That leads me to the second questions. There are a lot of layoffs happening right now, right? So if would it be fair for employers now to use this as someone who is on STD or LTD, which is short-term disability, or the long-term disability? Can they do that? Can they get rid of the role, eliminate, or something like that? Are they allowed to do that, or is it gray area, you think?
So contrary to popular belief, they can. The short-term and long-term disability, again, you'd have to be careful because the layoff, if you were, laying off an entire department, then absolutely. You can lay them off also. If it's seen as a termination, then you have to pay them their severance pay. But that would be your only obligation. If an employee had a return to work plan where they were maybe going to return to work within, 7 or 8 weeks, and you were only laying them off, it's not going to look fantastic, and it's going to look like the layoff/termination was related to their short-term or long-term disability.
Would it matter if employers are working under union? Would it be something that they have to take it up to the union?
Yeah, absolutely. So it's really important to remember, I'm so happy you brought that up, that unionized employees are, they're treated differently. So you really have to look at the collective agreement to see how any sick leave or termination is dealt with. Most of the time they're prevented from claiming wrongful dismissal, and there is a grievance procedure as well as arbitration procedure within the collective agreement. And then they've also got requirements relating to short-term or long-term disability. So unionized employee, look at the collective agreement.
Perfect. And let's say on the union, for example, it's not quite clear. They would say someone's going on a leave or someone's going on LTD, and it doesn't make it clear that we want you back by this, or we don't know, we cannot guarantee the role or something after a certain period. If it's open for interpretations there, what are the rights as the employee? Can they go hire a lawyer? Do they have to go back to the union, negotiate, and work through that?
So I would hire a lawyer. I'll give you a good example. We had a client that was unionized. She was denied long-term disability, and we went ahead and sued the employer and the insurance company for denying her long-term disability. They tried within their contract to say that she didn't have those rights to go to court, essentially, and fight the disability, decision. And, I was able to interpret the collective agreement in such a way that it actually didn't say that. So in the end, they ended up sort of folding and paying out her long-term disability anyways. So we ended the action. But I would definitely, as an employee, most employment lawyers offer free consultations. We offer free consultations. So definitely go ahead and speak with an employment lawyer, even if you're unionized, because we can likely make it so that the collective agreement is subject to interpretation.
Perfect. And have you ever seen, because I've had a couple of clients as well, so they were STD or long-term, let's say first year, it was declined for what, it was approved, and then let's say come in second year, they started to really drive them nuts, right? And they possibly decline or something like that, right? So what are your rights as the employee to actually go on with the LTD or CD? Can you hire the lawyer on that case, even if you're unionized or not unionized?
Yeah, absolutely. So the lawyer can work with the insurer, but again, there may be something within the collective agreement that will say that someone is hired within the company to work with the insurer, because your union rep essentially is the person that's supposed to be assisting you with any grievances or even short-term or long-term disability. But I would try both avenues. I would go to both and see what happens. They often change their decisions. So really the key is you'll usually have rights of appeal. And then once those rights of appeal are exhausted, you have to look in the collective agreement to see what next step is permitted. So in the example that I had, the next step was sort of ambiguous, and so really we could say, well, the next step is you are going to court. So it all comes down to the collective agreement, but do not hesitate to contact a lawyer, and they often change their minds.
Yeah, because I've seen that a lot as well. I like managing team as well in the past. Like people were asked to return back. There were a lot of paperwork going on, and there were a lot of meeting happening behind the door. What's the next step, right? And I've learned a lot as people leading in the team. And there are some biases and discrimination. I'm not going to sit here and lie, but there are some biases and subconscious decisions that's made based on the doctor's note, right? So that's amazing point. Now the other question that I have for you is what's considered reasonable accommodation by employer in your opinion? Do you have any examples of it for people who are sick, they're on the leave? What are the things that employers have to exhaust it out before they would say, no, you're not the right fit, it's not going to work for us?
Yeah, so reasonable accommodation, and lawyers, we love that word, reasonable.
Yeah.
It's essentially accommodation up to the point of undue hardship. So if accommodation is appropriate to create an equal opportunity so that your employee that is receiving the accommodation can perform at the same level as the other employees and reap the same benefits and privileges, then the accommodation should be made. But if the employer can make a case that it would cause them financial hardship, so for example, it's easier to sort of determine when you've got physical impairments, because if they're required to install quite a bit of equipment, and the employee's salary, just looking at the books, it doesn't make sense, then the accommodation is not reasonable. But typically what happens is, accommodations relating to physical or mental disabilities are typically given, whether it's remote work or it's, a standing desk or a ramp to accommodate a wheelchair. They're typically given. Where the difficulty lies is really in the medical documentation, which is often what people overlook. So the medical documentation will hint at the employee being unable to complete their job duties for an indefinite period of time. That's when the employer can safely say that the accommodation is not reasonable and there's been frustration of the contract. So I'll give you an example. I had a case where an employee unfortunately fell off a ladder and suffered a back injury. He was going through substantial rehab. He was off on short-term disability for a while, and they gave him quite a bit of paperwork once he slowly came back to complete. Eventually, the paperwork completely ran out and they didn't have any actual work to give him. At that point, they could argue that they can no longer accommodate him. Because it was a physically demanding job, economically and strategically, they did not have the means to accommodate him. That's when it would be undue hardship.
That's a good one. Now, let's go back to not the physical one, like in a mental side, right? Mental health are coming up. I've had a lot of clients who's taken sick days and it's converted to the from stress leave to LTD. Now, how do they measure that? Like when it comes to mental health, what are the medical notes that as an employee they need to go on? And I also remember me personally, when I actually took a stress leave in a corporate world, it was declined. For the first time ever, I went on stress leave ever in my career, and it was declined by insurance company. And then I didn't even, I know the paperwork and everything they made me feel, like it was so much documentations, and I had to pay literally so much, right? Whose responsibility is that actually to pay for that documentations? It's not cheap. Is it?
It's not. And, unfortunately, it's typically again, it depends. If you're a unionized employee, it would probably be provided for in the collective agreement that the employer will pay it. If you're just working for a private company, you often have to bear that cost. You can work with your employer to see if they would assist with the cost. But if it's you that's seeking the accommodation, you often have to bear the cost, because don't forget, they're going to bear the cost of actually providing the accommodation. But even in terms of mental disabilities, usually remote work is recommended. It's obviously more prominent now than it was before, because, for example, even certain companies that had no employees working from home had some employees working from home during COVID. So it's more feasible now. But I think that, it really depends. Again, going back to the example with the gentleman that fell off the ladder, it depends on if the company actually has remote work to offer. So, for example, if you're a retail employee and you require working from home, chances are that's not a reasonable accommodation because the employer financially cannot make that happen.
Mm-hmm.
Their bread and butter is in the store. So, again, it would be a frustration of a contract and you'd probably be without a job.
Okay.
Yeah.
The next question for you, since we're talking about remote work, a couple of my clients, they were working remotely. During pandemic, they were forced, obviously, and then some of the managers they were dealing with it was, okay, if you're working remotely, the contract doesn't say anything. First of all, there was no remote policy, nothing. It was just email, right? Okay, we are all gonna go and then work remotely until further notice because it's mandated requirement. And then they were also the funny part was, I don't know what is it. The manager was, you can't work remotely if you're not working from home. Let's say if you're going away in Toronto, which is like 3-4 hours away from where you live, you can't work from there. Like, can employers do that? Like, you know what I mean? When you're actually working from remote and you feel like you have to go and see doctors 4 or 5 hours away, and probably you would have to go and do the sleepover into the different province, whatever, right? But then as an employee, you don't want to give detail why you're traveling, right? So the employee just said, I'm going to log in from my, let's say, my mother's home in Toronto instead of, let's say, Sudbury today, which is like 5 hours away. The manager goes, no, you can't do that. You know what? It's remote work. You should be working from home. Log out and take your vacation. Is that a reasonable request?
So this is where employers fail most often. The employer has to have a remote work policy setting out where the employee is going to work from. Now, the remote work policy could say you need to remain in this province, or it could say you need to remain in this space. But when they don't have that, reasonably speaking, the employee could probably work from wherever they want. The only safeguard the employer would have is if there are privacy concerns. So if the employee being in a different location causes a breach of confidentiality or privacy of the employer, for example, working from a Starbucks and your screen is accessible, then the employer may have a defense to say, well, you can't work from wherever you please because it's going to infringe on our confidentiality or privacy. But otherwise, this is where the remote work policy is key and where many employers fail.
I know.
It's important to have a remote work policy in place. It's the only way to safeguard against it's really the only way to protect yourself from your employee traveling all over the place. Because what happens also is if they receive an injury in some other location, and that's something the employee needs to be mindful as well of, is if they're injured at a certain location, what happens to the workplace insurance policy?
Mm-hmm.
What if it's invalidated because all of a sudden you were traveling somewhere else? Now you want to claim short-term disability, but the insurance company says, nope, you didn't say you were working from there.
And the funny part was with the same client, what happened was the person went away on a leave of absence because of mental health. And the doctor says that he should be working from home because he has anxiety and stuff like that. You know, he needs the support. People are watching him at, home. And then doctors said that, and then he needs... and he's struggling at work as well, and then the manager says, no, you can't, because the doctor says that you need to be closely supervised, you need to be back here. And it's like, wow, what are the employee rights when it comes to that point where you feel like micromanaged, you don't want to give too much detail, and you are now feeling guilty, now I have to tell my manager what's going on, why do I need to work from home, right? Like, how much of information is too much from the employee perspective? But what do the employees do in that case when you feel like there's no supportive environment?
So the easiest way to think about it is, and you can also get this information from the Human Rights Code and Human Rights website, but essentially you just have to think about what would the employer need to assess when you can return back to work to normal. So it's typically, what treatment are you going through? Not necessarily a diagnosis, but what treatment do you have and what are your symptoms? The most important thing is, when can you come back to work? And, the employer can really ask what sort of accommodations you need. They cannot ask about the diagnosis, but they're within their right to ask about, what accommodations are required, what your symptoms are, and what your treatment process is, as well as what your end date is.
Okay. The next question is people on a leave of absence. If they have to travel for whatever reason, do they have to disclose to the manager? Could it be vacation? Could it be treatment? Like how far they have to notify? Or is let's say that there's no policy, nothing in writing, right? Do they have to notify insurance company or the employers or HR?
Now, is that when they're working from home and they want to
They're
travel?
yeah, they're on a leave of absence.
They're on a leave of absence. If they're on a leave of absence, they really don't have to say much.
Mm-hmm.
They can sort of go and travel wherever they please. The larger concern is if you're on short-term or long-term disability, because in that case, the insurance company, and we like to believe it's not true, but they do survey you. Mm-hmm. So they do watch your Facebook, and they're within their right to do so. They do hire private investigators. So I had a case where an employee was in a car accident and she was off of work. Now this was in the car accident file instead of, her going after her employer, but she went with her friends to Montreal, went out for a girls' weekend, wore heels, and it's all on video, and she said, well, I've got, permanent and serious back injuries from the car accident. I can't work. I can't do this. I can't attend school. And then sure enough, the insurance company of the motor vehicle that collided with her hired an investigator, followed her all the way to Montreal and took video of her, and that can very well be tendered as evidence. So you should just be careful. They can monitor everything. They monitor your Facebook, they look at your socials, and they look to see what you're up to. And that's true of any type of litigation. We even had a bankrupt, and his wife's Facebook was monitored, and that's how they... No, I think this was great. The only thing that I'll remind people is once you are terminated, and you'll see this all over my TikTok as well, or laid off, don't forget that you're probably entitled to a much larger severance than what's been paid.
That's why the employment contract are the first thing to negotiate when you get that.
Absolutely, 1,000,000%.
Well, you know what? It was such a pleasure. And for those of you who are listening to Tara for the first time, she's a LinkedIn Top Voice award-winning employment lawyer in Canada. I am going to bring her back. We've already talked about it. I'm not going to leave her alone. I want her back every month pretty much. And she said, okay. So we're going to do this over and over. And next topic we are thinking of is remote work policy, because we're talking about this. And Tara is amazing when it comes to it. That's her specialty.